Thank you very much for joining us today with this session of the CCSS online seminar series in computational social sciences. And it's a great pleasure to introduce our speaker today, Professor Mesut Hoca, Mesut Serdar Çekin. Mesut Çekin completed his undergrad and doctoral studies in legal education at the Faculty of Law at the University of Tübingen. At the same time, he worked there as a research assistant and also practiced law. He later completed his equivalency training at the Faculty of Law at Istanbul University. And he's been working at the Faculty of Law today at the Turkish-German University since 2012. And he's teaching and conducting research in the field of civil law. Focuses on the impact of technological developments on private law. He has published extensively on topics such as artificial intelligence, big data, blockchains, personal data, the digital economy, including books, articles, and papers presented at national and international venues. And he has contributed to public and international debates and legislations on these issues. And today he will speak on the legal aspects of web scraping. And he will explore the legal framework surrounding web scraping, its potential risks and boundaries, and what this means for us as researchers and practitioners working with online data. And so I'm also particularly very excited because Mesut Hoca has been advising as a board of advisor for for the ERC projects that we have conducted as the authority on these issues. And let me thank you once again, Hocam, for all your support. And we are delighted to have you with us. And floor is yours. Thank you very much.
Thank you very much, Erdem Hocam, and thank you for having me today. And also thank you for your kind invitation. And it's a pleasure for me to speak at the Koç University Center for Computational Social Sciences. And it's also good to speak to an audience which is not completely made of lawyers. My title today, my topic today will be the legal aspects of web scraping. And just right from the beginning, the basic idea of my talk is very simple. Web scraping may look like a technical act, but in practice, it almost never stays only technical. And because I know this is a method-aware audience, I will keep the engineering mechanics very short because many of you know better than me how crawling, parsing, extraction, and dataset building work. So I think the more useful thing I can do today is help draw the legal boundaries around those practices. That is my main topic today. So let's start with the simple question, why this topic matters now, especially. For many years, teams could act as if scraping was a background engineering issue, but today, as of today, this is much harder now. The first point is the need for data, of course, and especially regarding AI systems. So first, AI systems made the demand for large-scale data dramatically more visible. Of course, they need large data sets, but not only in quantity, but also at the same time in quality. When they need a lot of data, how do they gain this data? And in this context, there is the phrase publicly available data, which became politically and commercially very loaded. And in this context, what is publicly available and why is it so important? I just want to show a very short video of Mrs. Mira Murati. She was the former Chief Technology Officer of OpenAI. Once again, Chief Technology Officer. And there was a very simple question regarding Sora. I just want to play the video.
What data was used to train?
We used publicly available data and licensed data.
So videos on YouTube?
I'm actually not sure about that.
Okay. Videos from Facebook, Instagram?
If they were publicly available, publicly available to use, there might be the data, but I'm not sure.
Yeah.
I'm not confident about it.
So let's digest this very short video. She's the Chief Technology Officer of one of the biggest AI producers, and she cannot explicitly answer the question, which data did you use to train your AI, to train OpenAI or to train Sora? She couldn't give an exact answer, but she said licensed data or publicly available. But what is publicly available? And there was, as you can see, no exact answer to this question. Another example is Mustafa Suleyman, the chief AI chief in Microsoft, within Microsoft, who claims that every data on the internet should be freely open and usable for everyone. And I think this is an excellent opening example because it captures the entire problem in one phrase. In public discussion, publicly available often sounds like it's free to use, but in law, it does not carry that meaning so easily. So the next phase, we have the disputes regarding web scraping, data usage, and these were, first of all, NYT, the New York Times case against OpenAI and Microsoft, which turns public attention toward copyright, regurgitation, substitution, and harm to original publishers. What happened there? The New York Times argued in this case that its articles were copied and used to train AI systems without their permission, and that the outputs can sometimes reproduce or closely mimic NYT content. The legal issue is not just was data scraped, but whether copyright protections was used in a way that harms the publisher's markets and can still be defended as fair use in the US. There was another case, HiQ Labs versus LinkedIn. And the question was, what follows from scraping material that is publicly visible? What was the case there? HiQ Labs scraped publicly visible LinkedIn profile data with its automated bots, while LinkedIn tried to block and access and argued that the scraping was unauthorized. The legal issue was whether collecting data from publicly accessible pages can be treated like unlawful hacking, or whether publicly available access changes that analysis. At the end, the court decided that scraping is not automatically hacking, but can breach contract terms. But we will come to that point later. Then we had the case of X, or former Twitter, versus Bright Data, which this dispute likewise showed that public data access and platform control remain in tension. Bright Data collected publicly available data from X, and X argued that this scraping violated its rights and platform rules. The legal issue was whether a platform can use contracts by just saying in its terms and contracts, you cannot scrape data from my web page or my application, and access control theories to stop scraping of public-facing information, or whether that would effectively give it a monopoly over public data. Its claims were dismissed, by the way, by the court. So the modern environment forces us to think in layers. The question is no longer just, can a crawler technically collect this data, but rather under what access conditions, for what kind of data, and for what downstream use will you scrape data. So, and I can
Data what?
oh, there. Just very short, as I said before, you are better than me in this context, but I think if I had to reduce the technical side to just 3 questions that would be relevant in legal context, these would be: how do you access, what do you take, and what do you do with it? First of all, how are you getting in to scrape this data? Is this a public page? Is there a login wall, a paywall, or a setup with anti-bot measures like rate limits or captchas? That especially matters for contracts and sometimes for unauthorized access arguments. So if there are technical barriers and you're getting into this page and scraping the data, then it might technically lawfully be qualified as hacking the website. So it's first of all, it's very important. How are you getting in? The second question would be then, what exactly are you taking? Is it raw factual material, right, like prices, dates, or structured files? Or is it protected expression like articles, photos, codes, or lyrics? And does it also contain personal data? That will also be a very, very important question in legal aspects. And the third question would be, what are you doing with it afterwards? Are you only analyzing the data? Are you using it for text and data mining purposes? Are you training a model, republishing, summarizing? Are you building a product that may substitute the original source? And the legal answer can change a lot depending on that last step. And maybe building a product that may substitute the original source. A few days ago, Claude once again, I think, published the original source code. And there was a guy, a very smart guy, who could reproduce the whole code within, I think, a few hours, and published it on GitHub, and get a lot of more than I think a few thousand stars on GitHub. Yes, and one point that is worth saying at this point is that robots text matters operationally, but it is not the same thing as a legal permission slip. There we should also be careful. So, what are the legal aspects? Before I get into details, let me define the basic pieces. Because there is no one law which regulates web scraping. There's not only one regulation where we can rely on and say, okay, this is legal or this is illegal. There are many fields, legal fields, which are affected when we want to scrape data. And therefore, I have this. I want to call it the legal stack. There, I chose 5 fields which are for me very important. The first one is copyright. What is copyright? Copyright is about protected expression. Very roughly, the law does not ask only whether something was copied. It asks what kind of thing was copied, whether that thing is protected, and whether there is a rule or exception that helps you. Think about once again about the New York Times case. New York Times claimed that its style, its art of writing, its art of publication was copied, mimicked by OpenAI. The next layer would be, of course, privacy or data protection, but data protection law does not ask whether the material which was scraped is copyright protected or not, but it's another question. If the material relates to a natural person, the law wants to know why you are processing this data, on what legal basis you're processing this personal data, and with what safeguards are you processing this personal data. Then we have the contracts law layer, which comes in because the platform itself may say in its terms and conditions. I don't know whether you have ever read this when you visit X, when you sign up to Google, or just open a video on YouTube. There are always somewhere at the bottom of the page, or always these terms and conditions. And in these terms and conditions, they mostly say you may not scrape, automate, extract, or reuse the service. In this way, you are not allowed to scrape data from my web page, or passages like that. I will also show an example later. We have then the unfair competition layer, haksız rekabet, we call it in Turkish law. What is it about? Unfair competition can matter when the complaint is not just you copied something, but you built your service on top of someone else's finished market work in a way that looks like systematic free riding. So when I crawl all the data from the newspaper, from NYT or somewhere else, and then I have a tool which can create newspaper articles. Then I have profited from New York Times investments, and this is also this may also lead to legal consequences, and therefore I think unfair competition is another aspect we should take into consideration. And finally, the European Union's AI Acts, Artificial Intelligence Act. It was published, yes, but its application has been once again delayed because it's a very complicated law, and compliance with this law and its obligations is very difficult. But we should nevertheless examine also the AI Act. This is not a scraping law as such, but increasingly matters once scraped data feeds regulated AI systems. AI Act regulates AI systems as products. It's a product security regulation. And when you use scraped data for training or evaluation within this AI system framework, then AI Act may matter. So I think this framing is useful because it avoids false simplicity. You do not need to memorize all the law, please. Never. But I think it's important to have a sensibility. You do need a good map of the different questions the law is asking. So when you want to start a project, whether at a university research center or in your own startup, in your company, I think these questions should always be kept in mind when starting and designing and developing a project. So, as I said, these are the fields I want to talk about. And let's start with copyright, because copyright was always, at least at the beginning, it was the most debated issue. But let us first slow down for a moment and define a few terms that lawyers often use as if everyone already knows them. So first of all, let's start with what is copyright? For our purposes, copyright protects original expression. Think of things like articles, photographs, song lyrics, codes, or creative selection and arrangement. It does not put every raw fact in the world. So today is the 2nd of April. This is just a fact. It's not protected. But an artistic photograph of me or a book written by me may be a copyright protected material. So it does not protect every raw fact in the world. That is why the classic distinction is facts on one side and expression on the other. So the basic rule is you cannot use copyright protected material without consent of the right owner. So if you are scraping and the material contains copyright material, copyright protected material, then we are in legally dangerous zones. Second point, what is text and data mining, TDM? It's very important because European law, especially, contains very important exemptions regarding TDM. In simple terms, it means automated copying or extraction so that you can detect patterns, compare, classify, search, analyze, or train at scale. In other words, TDM is not about enjoying the work as a human reader. It's about using material as input for analysis. Why is that important? Because, as I said before, if you use copyright protected material for text and data mining purposes, the law foresees very important exceptions to the general rule that copyright protected content cannot be used without permission. The third point I want to touch upon is the European Union scientific research exemption. The EU has a law called the Digital Single Market Directive, DSM Directive. This directive aims to create a more balanced framework for creators, right holders, platforms, researchers, and users by improving licensing, access to content, and certain exceptions such as text and data mining. And under Article 3 of this Digital Single Market Directive, research organizations and cultural heritage institutions get a stronger text and data mining exception for scientific research, as long as the material is lawfully accessible. So this is not a general free pass for everyone, but it's a more specific research-oriented route. This also goes for web scraping. And then comes the tricky part, of course, when does scientific research start and where does it end? The answer is not simply non-profit good, commercial bad. In practice, the line is more nuanced. A university project may have future commercial relevance. A public interest study can involve private partners. The harder question is usually about the institutional setting, the purpose of the activity, the access conditions, and whether the use still looks like genuine research rather than straightforward product exploitation. And if you are not in this research exemption area, Article 4 of this Digital Single Market Directive becomes very important. It creates a broader text and data mining route for lawfully accessible works, but right holders, in this case, right holders can opt out. So if you're not scraping for research purposes, but for example, commercial purposes, the right holder, the copyright owner, has the right to say, no, you are not allowed to scrape my content. But as I said before, there is a rights reservation, and this becomes very important. And then I have Japan. There is an interesting article in the Japanese law, Article 30, Section 4 of the Japanese Copyright Act, which says, if the use is not for human enjoyment or appreciation of the work, and if it does not unreasonably prejudice the right holder's interests, then information analysis uses may be treated more permissively. So if you don't scrape data for human enjoyment purpose, then you may be allowed to use this data, to analyze it, to republish it. This is a very interesting case, and I think we should not only focus on America or the EU, but the Japanese way is also an interesting example. So the practical takeaway at this stage is this: the same data set can produce very different copyright answers depending on who is using it, a research organization, heritage foundation, for what purpose, research, commercial, under which exception, text and data mining, and in which legal system, whether in the US, in the EU, or in Japan. But since we are in Turkey, here's Turkish law, we should also mention the Turkish law perspective. The problem is that Turkish copyright law does not have a broad, standalone scientific research exception comparable to the European Union DSM directives, text and data mining exceptions. Instead, it relies on narrow and specifically listed exceptions, especially quotation, iktibas, and some limited education-related uses, eğitim, öğretim, araştırma istisnası, it is called. And in practice, these exceptions are interpreted rather restrictively, so they're relevant mainly for classical academic citation and explanation, not as a broad legal basis for large-scale scraping, dataset building, or AI training. And there is unfortunately also no text and data mining exception like in the EU. Yes. So that was the copyrights perspective. Now we move on to the question, once again, scientific research. As we are in a scientific institution, as here are a lot of researchers, I assume, I wanted to go deeper to this topic. And this is also where the abstract ideas start to feel more real. I mentioned Article 3 of the Digital Single Markets Directive, and it is not a floating exception for anything that looks intellectually serious. It is tied to research organizations and cultural heritage institutions and to scientific research. So if the activity begins to look more like a commercial product pipeline than a research project, the argument becomes weaker. That said, scientific and commercial elements can sometimes exist together. Of course, real life is messy. Universities collaborate with companies. Research may later be commercialized. Publicly funded work can generate spin-offs. So the legal question is usually not whether there is any commercial dimension at all, but whether the use still sits credibly inside the structure and purpose of the research exception. And once that becomes hard to say, then we can switch to Article 4, or licensing starts to matter much more. Licensing, we have to pay money. And this is also why I want to mention 3 very important recent decisions regarding Article 3 and Article 4, all these scientific research exceptions. The first one would be the Lion decision from the courts in Germany in Hamburg. This case started with a photographer saying, my image, my photograph, a photograph which I took, my image ended up in an AI training dataset without my permission. The legal fight turned on whether Lion, this was the database owner, could rely on the text and data mining exception for scientific research, and later whether the rights holder had a valid opt-out. So what was the point? The photographer said, on my web page, I have pictures which I made. I took these photos, uploaded on my web page, and in my terms and conditions, I said, but without a robot's text file, please. He just said in his terms, data scraping is not allowed. And now comes Lion, which is a research organization. It compiles large data sets and gives it free to researchers for AI training purposes. And Lion said, this is I'm a research organization. This is a scientific research what I'm making. I'm making data available for AI researchers, so I should be within this exemption. And at the Hamburg court discussed this issue, and then at the next step they discussed also the point: what does opt-out mean for a copyright holder? Is it enough if the copyright holder just says in terms and conditions, you are not allowed to scrape my data? Or should it also include a robot's text file, or in legal terms, should it opt out in a machine readable formats? And later, the higher court in Hamburg said, no, it must not contain a robot's text file. It is enough if you just say in your terms and conditions, you're not allowed to scrape data from my webpage. The next case is Gemma versus OpenAI. Once again, Germany. This time it was a Munich court. The point was Gemma is GEMA is the German Collecting Society for Copyrights, and it's said, if I ask ChatGPT what the lyrics of an older song in Germany, how the lyrics are, ChatGPT can give me all the original lyrics. What does that mean? ChatGPT makes the a copyright protected content. Song lyrics are copyright protected, and ChatGPT can give me all the original contents. That means, argued the German Munich court, that means that you, ChatGPT, have memorized all these lyrics. We don't know whether this is technically right or wrong. It was not discussed in the final word of the court. I think the higher courts will discuss this topic later on. But the first court just assumed, just said, if it can give me the original lyrics, then it must somehow be memorized by ChatGPT. So there was then a copyright infringement, said the court, and at the end, OpenAI was sentenced to delete the memorized lyrics of the copyright protected song. And then we have the London court's Getty Images versus Stability AI litigation. In Getty Images versus Stability AI, Getty alleged that millions of its images were scraped and used to train Stable Diffusion without permission, while Stability challenged both the factual basis and the legal framing of those claims. The case became especially important because it showed that in cross-border AI disputes, the court asks very concrete questions about where the allegedly infringing training happened, under which national law, and on what evidence. Several Getty claims were narrowed or abandoned as those proof problems became decisive. So If I had to put it in one sentence for non-lawyers, it would be this: copyright risk is not only about what goes into the model, but also about who collected it, under what exception, and with what reservations, and what comes back out. These are all relevant questions within the framework of copyright law. What do we have next? Of course, privacy. Once again, the same kind of short reset for data protection. What is personal data? In simple terms, it is information relating to an identified or identifiable person. That category is very broad. Names, surnames, profile details, photos, voices, location signals, and even combinations of data points can fall into this definition of personal data. And what is processing? Also a very broad definition. Collecting, storing, sorting, labeling, analyzing, combining, and using data for training can all count as processing. So scraping personal data is already part of the legal story before you ever deploy a model. And what is a legal basis? This is the simplest way to explain it. Data protection law does not want personal data to be processed just because it's technically available. The law asks, why are you processing personal data? And what legal reason do you have for doing it? Under GDPR and the Turkish data protection law, KVKK, that might be consent, contract, legal obligation, legitimate interests, and so on. The important point for this audience is that some legal basis has to carry the processing. So the shortest privacy message is this: public on the web does not mean legally free for any reuse. Large-scale scraping can also trigger transparency duties if the data was collected indirectly. Article 14 of the GDPR, and we have also Turkish regulations, may enter the picture, which says that you have to inform every data subject whose personal data you are processing about your activities. And at scale, that becomes hard very quickly, which is exactly why regulators keep returning to safeguards, filtering, minimization, and documentation. And from a Turkish data protection perspective, just because data is visible does not mean it has been lawfully made public in a legal sense. The Turkish Data Protection Board repeatedly stresses that what matters is the person's will and purpose. If someone shared data for one limited reason, you cannot automatically reuse it for another purpose. So the engineering translation is straightforward. If your data set contains personal data, you need a legal basis story, a necessity story, and a safeguard story, not just a working crawler. What do we have next? Contracts and terms of service, often the fastest red light. The contractual layer is often the fastest way into avoidable trouble and probably one of the most underestimated. Many services say quite directly in their terms that scraping, automated extraction, or similar conduct is not allowed. Examples for YouTube, for example, I have here. YouTube terms of service prohibits access by automated means such as robots, botnets, or scrapers, subject to limited exceptions. The same goes for LinkedIn, which states automated crawling and indexing without LinkedIn's express permission is strictly prohibited. And then we have X terms of service. Users cannot scrape the services without access express written permission. And in Europe, there's an extra twist. These terms, as I said before, within the Digital Single Markets Directive framework, these terms may not matter only as a contract, but also as part of the text and data mining opt-out story. So when people say terms are just boilerplate, that cannot be much too casual. My practical advice is to treat terms the way you treat API limits or product constraints. They are part of the environment you are operating in, and they can change over time. So please be careful about these terms and conditions. Unfair competition, Turkish law. I also want to add this Turkish law angle that is often missing from scraping discussions, and that is unfair competition. We should be careful here. Not every scrape is unfair competition, but the argument gets stronger when extraction starts to look like systematic appropriation of someone else's market-ready work, especially if the new service begins to substitute the original source or write on its investment. This lens matters because sometimes copyright is not the whole story. Sometimes the real complaint is economic. You benefited from another actor's organized effort, audience, and investment without carrying the same burden yourself. This is especially the case for news agencies who are complaining about the use of their articles for training purposes. If the article of the newspaper is not copyright protected, that could mean, okay, then you can use it as you wish, and you can profit from it. But the newspaper, the news agency has invested, has paid money for reporters, for its website and everything else. And what are you doing? You're just scraping the data and developing a product which can substitute the newspaper. So this could be treated or classified as unfair competition within the Turkish law system. There's also a legislation in process in Turkey called Dijital Telif Yasası, according to which website operators like Google should be obliged to pay license fees to new agencies in order to use their news articles. For a research audience, the practical translation is simple enough. Analytical, limited, non-substitutive use is easier to defend, but repeated, organized, commercially substitutive extraction is harder to defend against claims. And then finally, we have the AI Acts. The AI Act matters here because it's not just about banning a few extreme AI practices. At its core, it's a market and product safety regulation for AI. If you develop, place on the markets, import, distribute, deploy, or use certain AI systems in the European Union, or if you sell these products to the European Union, the law asks what kind of governance, documentation, and control structure you must have in place. That is why scraping matters under the Act, even though the AI Act is not, strictly speaking, a scraping law. If scraped data feeds a high-risk AI system, these high-risk AI systems are defined in the AI Act in a very complicated manner. But if you're developing, if you're selling a high-risk AI system and you feed scraped data into this high-risk AI system, the compliance discussion quickly turns to data governance, technical documentation, logging, and post-market monitoring. In other words, you may later have to explain what data you used, where it came from, how it was prepared, and how the system was monitored over time. So you cannot just say, I don't know, it was licensed or publicly available. And what do you mean by publicly available? I don't know. I have no further information. This is not an excuse anymore regarding AI Act in the European Union. And there is also one, and the same accountability logic appears in the general purpose AI regime. Providers of general purpose AI models must keep technical documentation up to date, maintain a copyright compliance policy, which is especially the case for ChatGPT, Claude, and all these LLMs, all these big models, they have to maintain a copyright compliance policy and publish a summary of the contents used for training. So from a scraping perspective, the practical message is simple. You cannot just say, we found it on the internet. Sooner or later, you may need to account for the origin and governance of that data in the European Union. There is then one additional point where the Data Act speaks very directly to scraping. It prohibits certain AI systems used for creating or expanding facial recognition databases through untargeted scraping of facial images from the internet or CCTV. So in that space, the issue is not only documentation, the law prohibits the practice itself. Okay, we are nearly at the end. These are now my messages I want to give. Treat scraping as a governed data supply chain, not as a crawler. And this is the slide where the legal discussion turns into project design. If I had to compress the whole talk into one operational idea, it would be this. Do not think of scraping as just a crawler. Think of it as a governed data supply chain. At the collection state, you need to know your sources and access conditions. During preparation, you need filtering rules, transformation logs, and version discipline. During analysis or training, you need to know what entered the dataset, what was excluded, and what legal and technical assumptions were made along the way. And I like this framing because it works almost everywhere. It works for a university lab, a startup, a civil society project, and a product team. The level of governance may, of course, differ, but the logic should be the same. And then we have this famous saying in Turkish, yukarı tükürsem bıyık, aşağı tükürsem sakal. Özür dilerim, affınıza sığınarak. Ama this is the final point. There is no zero cost strategy. Teams often hope that there is a frictionless option, legally safe, technically strong, cheap, and comprehensive. In practice, that option rarely exists. Licensed data sets might buy you more certainty, but they cost money and often reduce breadth. Public factual data with strong filters may be more manageable, but still needs terms and privacy review. Privacy-heavy datasets may require minimization, deletion, or privacy-enhancing technologies like anonymization techniques or encryption, but they can at the same time reduce utility. And governance itself costs time, people, and documentation effort. So when I say there is no zero cost strategy, I definitely do not mean there is no strategy. I mean that every serious strategy comes with trade-offs among coverage, utility, licensing costs, legal uncertainty, and governance burden. So let me close by coming back to the simplest version of the message. Web scraping is not one legal question. It is a stack. The key variables are access mode, data type, downstream use, and governance capacity. Change those variables and you change the legal picture. So there is no single universal answer to the question, is web scraping now legal or not? The better question is, legal under which access conditions, for which data, for what purpose, and with what controls? And I want to resist two easy mistakes. The first is panic. The idea that scraping is automatically unlawful. No, it is not. The second is entitlement. The idea that if something is online, one may simply take it and use it however one likes. And that's not true. The line I would leave you with is this. Online visibility by itself is not a blank check, but the law is also not telling us that every scraping project is forbidden. what it is telling us is to be more precise, to ask better questions about what we collect, why we collect it, and what we plan to do with it. So, thank you very much for your attention, and I look forward to the discussion.
Thank you so much, Hocam. This was wonderful. Thank you. May I ask the first question? So we have our master's program, and all of our students are here, and so I can talk about like not an average, normal, or standard, by like an expected research, a master research project in our department. Our student is using Twitter data to analyze a political behavior, like the effect of economic situation, economic crisis on entire immigrant sentiments in Turkey. And the student will collect data, scrap tweet data from Twitter, and run AI models, machine learning models, to produce some metrics, and then test some hypotheses and publish the thesis. So, is this legal?
As I said before, there are many dimensions.
So yeah. So
First of all,
can you walk us through this in this specific scenario? Can you walk us through the steps of reasoning?
yes, of course. From the Turkish perspective, this is a scientific research. We have our very narrow exemptions within the Turkish copyright law, but I think this should still apply. And there's just a tweet should also not be treated as a copyrighted content, I think. So copyright law, I don't think that we are that there are legal risks. The second point should be terms and conditions. And the X says in its terms, you cannot scrape my data. Well, this is problematic indeed, because when you sign up to X, or when you just visit the website, it claims that we are signing a contract. I'm offering you my services, and you are using the services, and by using the services, you're making a contract with me, and you have to respect my terms. And in these terms, X says, no, you cannot scrape data from my website. So this could be problematic. Of course, these are general terms and conditions, and we have in Turkish law regulations regarding general terms and conditions, and whether this is fair or not, just prohibiting even for research organizations. Well, there is no clear answer, but it is risky from contract law perspective. About personal data, and within the personal data law, we have also research exemptions, and I think they can apply. And if we have then also privacy enhancing technologies like differential privacy or anonymization techniques, then it's just better. So we can minimize the risk within data protection law. And I think unfair competition should not be the case. We are not pursuing. We have no commercial purposes. They're just scientific purposes. So it should not be classified as unfair competition. And lastly, AI Act. We don't have AI Act in Turkey, so that should also not be a problem. In the European Union, once again, we have the Digital Single Markets Directive, and there we have the research exemption. And this is, I think, a very good example for research exemption and for this data, text and data mining. And I think, and on regarding copyright issues, we're on a pretty safe side. But I think the only problem should be terms and conditions of Twitter. And that is exactly also the problem. When these big platforms, when they say, okay, my content is not copyright protected, it's not commercial secrecy, which is also protected by law. And if it is not personal data for me, it's personal data of the user, yes, but not of the platform. So what remains? It's just contracts law. And I can only operate by claiming we are making a contract, and if you use, you have to respect my terms, and in these terms, I forbid you to scrape data from my web page. But then, if X comes today and claims you have extracted, you have scraped tons of data from my servers, then it has to prove this facts. And then we have, of course, this classic issues of proof.
So it bears some sort of a risk being sued by Twitter in the future.
Yes, Hocam. The problem is, especially in this technical or tech law area, you can never say this is legally okay and this is lawful and this is not this is unlawful. It's very difficult to say. We have no zero and one, but all these gray areas. So you just had a simple question, and I had to argue. I had to answer within 5 minutes. But that's exactly the case, and that's exactly also the problem. There are also not a lot of courts which are technically which don't have enough technical know-how to examine cases like this.
Okay, thank you very much.
You're welcome, Michelle.
Serdar Can, thank you so much. That was a fantastic presentation, and that also brought with it a lot of questions in our chat box. Here's what I'm going to suggest. I mean, I think we have close to 10, maybe even more questions. And we have about half an hour left. Would it be okay if we collect like batches of them and you decide which ones you would like to answer directly? Some of them are kind of speaking to one another, so it may be easier to get them in some batches. Would that be fine?
Of course, of
Okay,
course.
so I'm gonna read them out loud. So we will be uploading the recording later on YouTube, so people watching after the seminar can also easily get the questions. I also invite our participants to send their questions to not as a direct message, but to everyone, so Serdar Hoca can also see it easily. I'm starting with Rümeysa Türkbey's question. I wonder what the legal consequences of scraping copyright protected documents are. Let's assume we have done it unintentionally. Moving on to Yunus Emre Gündoğmuş, who's asking, is a website's use of robots .text to prohibit scraping legally binding, or is it merely a technical signal? And the next question comes from Şükrü Atsızelti. Do we have legal cases related to data scraping in Turkey, like legal cases against ChatGPT and others in USA? So maybe we can start with the first three questions and then move on to the next batch, if that's all right with you, Hocam.
So to start with, Rümeysa's question, legal consequences of scraping copyright protected documents. The general rules apply. So if you infringe copyright owners' rights, then you have to pay compensation, license fees, and different kinds of compensation, tazminats. That's the legal consequence. It's not as dramatic as infringing other rights, such as marca, patents, and so on, where you can go to prison. But within the framework of copyright law, I think there is just compensation in terms of paying money, license fees. The second question from Yunus Emre Bey was, Meri Hocam, could you maybe repeat the
I
question?
can repeat, but I also ask our participants to type their questions in the general chat box so we don't have to repeat
That
them,
would be
right?
great.
Thank
That
you,
would be great.
everyone. So Yunus Emre had asked, is a website's use of robots .text to prohibit scraping legally binding, or is it a merely technical signal?
Well, first of all, it is a technical signal, yes, but at the same time, in the EU, under the Digital Single Market Directive, it says you have to, if you want to opt out, you have to do it in a machine readable format. And machine readable format means classically a robot's text file. So if you have included in your web page a robot text file, that automatically means you have not only in technical terms opt out, you're not only technically rejecting any crawling activities, but also legally at the same time. You are forbidding data scraping, web scraping on your websites.
And then there was a question from Shukru about the legal cases related to data scraping in Turkey.
Well, I personally do not know any of these cases. There were about data portability, but about legal scraping, I personally do not know about any cases in Turkey yet.
Thank you very much, Hocam. So I will read the next three questions that were sent in the general box. Berke Elibol is asking, thank you for the great presentation. My question is that if copyright protects expressions, how is the boundary determined in practice, especially when collecting data at scale? And the next question is from İlayda Küçükafacan. Platforms invoke legal mechanisms like terms of service, GDPR, to restrict scraping and API access. Yet the very same data gets licensed to well-resourced actors like OpenAI or Anthropic through commercial partnerships. The law, in practice, isn't applied uniformly. It blocks the researcher but opens a side door for the paying partner. Over time, this consolidates data access into the hands of a few dominant players, creating not just asymmetry, but a structural monopoly over the raw material of AI development. So here comes the question. Doesn't this create an asymmetry or even discrimination where legal access to web data becomes a function of financial power rather than legality per se? And if so, can we still call this a legal framework, or is it more honest to call it a market access framework dressed in legal language? I'm going to pause here and not take another question because this is kind of a heavy one, I would say. So let's answer the first two, Hocam, if that's all right, and then we'll move on to the next ones.
Of course. Let's start with Berke Bey. Well, very nice question. How is this boundary determined in practice, especially when collecting data at scale? Well, there are tons of disputes in Turkish courts about the question, is it now a copyright protected content or not? The problem is expression, or we call it in Turkish law eser. What should be qualified as eser and what is not qualified as eser? Because if it is qualified as eser, then it is protected. If not, then it's not protected. So what are the boundaries? And especially, what is an expression? Just taking a basic, a very simple photo on your mobile phone, cell phone may not be qualified as an expression, but if the same is done by Ara Güler, who sadly passed away, then this could be qualified as an expression because he has his own style and light and shadows and so forth. So even without the aspect of data scraping, it is difficult to decide whether something is an expression or not. And of course, this if you are scraping data in large scales, becomes more risky because it can contain just facts or factual raw data, but as soon as something slips in which can be qualified as copyright protected material, then we have some problems. And there are also some attempts to classify data as raw data and copyright protected data, but the legal boundaries are not very clear. And to the second question of İlayda Hanım, wow, she has put the whole discussion to the point. She made it very clear, and that is also the problem because especially in the European Union, as the following problem. When we talk about data, we are constantly talking about protection, copyright protection, personal data protection, trade secrets protection. Everything is protected. Everything is protected. And if you infringe these rights, you have to pay compensation, you have to go into jail, and so forth. But data is an economic value. And if you can extract this value, the whole economy will profit from it. So the European Union, for example, started or enacted two important acts. This is the Data Act and the Data Governance Act, which both aim to build the legal framework for data markets within the European Union. You have the right as user of an IoT product to claim your data. So if you use an autonomous car, a smart car, which produces data constantly, you are now in the European Union allowed to ask your car manufacturer to give you the data which was produced by you using this or driving this car. But yes, there is, of course, an asymmetry, and it is also not very clear how these social media platforms, especially, how they collect this data, how they package them, and under what conditions they sell this data. Is it really perfectly legal or not? Is it analyzed data or is it raw user data which is being sold to another partners? So and this is also a reason why all this happens not in the European Union, but in the US. You have the big data brokers in the United States and not in the European Union. This is, I think, a very important point because their laws are very liberal. they have enacted, yes, privacy laws in the recent few years, but they have a large economy where data brokers are willing to sell large amounts of also personal data. So, and there's, of course, then the question, the very important and very, I think, a good question to ask. Okay, if they profit, if they have a monopoly, then why do we protect all this data? And therefore, as I said before, the European Union tries to extract this value from the data by enacting new laws. But this is also a trade-off. If you say, I want to create a data economy and earn money with this data, then you have to go down with all these protection regulations, like the US. But if you say, no, personal data protection, copyright, these are all uh, civil fundamental rights, like property rights, right to personality. These are fundamental rights and questions. They are very important for us. Then you have to skip that argument with the data economy. So this is also at the same time a very important political issue.
Thank you very
İlayda Hanım,
much.
I didn't, sorry, Mary Hocam, I didn't answer the question directly. I'm sorry, but there are many dimensions, and I cannot give a very short, strict, straight answer to this very good question.
Thank you very much, Hocam. So the next question is coming from Helin Özdemir. My question concerns a personal research use case involving Reddit data. Given Reddit's current access restrictions and the availability of third-party historical Reddit archives, would citing the source and fully anonymizing all identifiers make that approach legally defensible? Or do the platform's terms, licensing conditions, and deleted content obligations mean I should rely on an officially authorized access route? And the second question is coming from Şevval Çakıcı. Thank you for the presentation. Was wondering, where do you personally stand on this? Since scraping can sometimes happen unintentionally and rules differ across countries, do you think we need more common or standardized practices for data collection and AI training? There is one last question that is not, I think. Oh, as a matter of fact, I have four more questions that were DM'd to me, but I would suggest answering these two first, and then if you have any remaining time, we'll move on to the last batch.
Okay, let's start with the personal research use case. Well, yes, it's that's the point of being a lawyer. Sorry, it's risky. It's risky, and relying only on an officially authorized access route is the most safe way. Yes, it's the most safe way. But I must look into details. I must examine first Reddit's terms and conditions, and also the data which is being cited or gained, obtained, and then I can give a definite answer to this question, Helena. And the second question, Şevval
Şevval.
yes, since scraping can sometimes happen unintentionally and rules, yes, across countries. Yes, we should definitely have common or standardized practices for data collection, and definitely yes, yes, yes, yes, yes. But I think that it's always a problem or an fact. It's an attitude problem. As I said before, the US sees the whole thing from the utility perspective, or China as a better example. China says, if I can earn money, if I can if it is useful for my technical development, then privacy may get into the background. Then I think this is more important. The US, if it is from the utility perspective, if it is useful for the economy, then everybody profits from it. So personal data protection may be of secondary importance. On the other hand, the EU says no, data, especially personal data, is very important for us because it's a matter of protection of the person itself. So data protection is always our top priority. But I think there will never be standardized practices. I think I wish there would sometimes be these practices, but I don't think they will ever be available because of the different attitudes of different countries regarding personal data, copyrights, and fundamental rights.
Thank you very much, Hocam. And the last batch. And I noticed none of these questions were actually put in the general box, I think, but I'll read them out loud anyway. So the first one's coming from Alpata Turkolu. Throughout the presentation, we talked about big cases regarding huge corporations. I wanted to ask, in practice, how likely are we, as independent small researchers, to come face to face with the legal ramifications of web scraping? To specify, I'm not asking about coming up against research regulations regarding these processes. I want to ask, how likely are we to face actual legal consequences? The next question.
Maybe
Sure.
Hocam, I'm getting old and I'm forgetting the questions, so therefore maybe I will give right away short answers
Sure.
if you may.
Of course.
Thank you. Well, in Turkey, I don't know of any case, but the first spectacular case was indeed, I think, a Turkish guy who scraped large amounts of data from Facebook and was then sued in the United States. So if you scrape very large amounts, it is possible. Whether they sue you in Turkey, I don't know. Whether they will sue you in Turkey, I don't know. But you cannot say it's impossible. There is always this possibility. But if you are doing it for research purposes, for solely research purposes, I don't think that the outcome will be a dramatic one. At least I can say that with safety.
Thank you, Hocam. Next question is from Mehmet Badınlı. Hocam, thank you so much for this eye-opening presentation. I was wondering, do you think TDM exceptions should be further expanded into the future due to the rise of LLMs?
Yes, there is indeed just this discussion because as the text and data mining exemption was enacted in 2019, 20s, I think, there was no real ChatGPT as we know it today, or there were no LLMs as we know them today. And there is, within the doctrine, within the legal scholars, there is an opinion which says the legislator couldn't see the LLMs coming, and the TDM exception is only for this little data analysis programs, and it is not applicable to LLMs. But there is big number of scholars, legal scholars, who say, well, yes, as the TDM exception was enacted in 2020, I think, there were no LLMs, but we can apply the same idea to LLMs. And we can, the TDM exception is already applicable to LLMs. And this is, I, I can say they are the majority of the legal scholars who claim this.
Thank you, hocam. The next question is from Saliha Nur Gökçe, who's thanking you for your presentation, asking, I wonder if a data set is initially collected for analysis only, but the resulting insights are subsequently integrated into a commercial model. Does this violate the TDM exception?
A very good and tricky question. At the time where you are, well, it could get problematic if you have the following. If you, from the beginning, from the starting point, you know that you will, at the end, commercialize the product, but you want to use the research exemption just to gain the data without licensing it. If you go this way and want to circumvent the legal regulations, then this is problematic. But if you really start, and it's your intention to make research, and then later you turn to commercial purposes, this may be justified. But once again, it depends on the facts of the concrete case.
Thank you, hocam. And I think this will be our last question. I'm quickly checking the chat box. Yes. The last question is coming from Emre Güzeldal. If TOS function as a TDM opt-out signal under European law, does that mean platforms like X could retroactively claim copyright reservation through a terms update, and would that hold up?
Well, the opt-out or rubber text only applies if you want to scrape the data for commercial purposes. If you're a research organization, then they may opt out, but this is not relevant from the copyright perspective.
All right. Oh, thank you so much, Hocam. With that, I think we can conclude. I hope I'm not missing any of the questions in the chat box. I think not. But if so, I invite the participants to direct their questions to Serdar Hoca directly. Thank you so very much for this fantastic presentation. We learned so much from it. And I also would like to thank our participants for this really fruitful debate we had. With that, I'll also pause recording.
Hocam,